Interpretation number 812. Interpretation number 812, Educational Compulsory Labor. Issue is the provision of educational compulsory labor under the Criminal Code, the rehabilitative measures for burglar and offense of Criminal Act, and the Organized Crime Prevention Act unconstitutional. Holding the Criminal Code was amended and promulgated on February 2, 2005, and became effective from July 1, 2006. Article 90, paragraphs 1 and 2 of the Criminal Code stipulate that any person who is a habitual criminal or commits an offense because of habits of loitering or vagrancy before execution of punishment shall be committed to a labor establishment to perform educational compulsory labor. The period for educational compulsory labor prescribed in the preceding paragraph shall be 3 years. The Theft and Robbery Offenders and Security Measures Act was amended and promulgated on May 30, 2006, and came into effect on July 1st of the same year. Article 3, paragraph 1 of the Act stipulates that those who are over 18 years old and have a habit of committing theft or robbery of stolen property shall be sent to a labor institution for educational compulsory labor before the execution of the sentence. Article 5, paragraph 1 of the same Act stipulates that the period of educational compulsory labor imposed on this Act shall be 3 years. These provisions violate the principle of proportionality of Article 23 of the Constitution and are inconsistent with the spirit of Article 8 of the Constitution, which guarantees the liberty and the security of a person. Therefore, they shall be invalidated from the date of this interpretation. Article 3, paragraph 1, 3 and 4 of the Organized Crime Prevention Act, as amended and promulgated on April 19, 2017, stipulates that those who commit the offense under paragraph 1 shall be sent to a labor institution for educational compulsory labor before the execution of the sentence, and the period of this punishment shall be 3 years. Although the paragraph was amended on January 3, 2018, it still violates the principle of proportionality and the principle of clear distinction required by the Constitution, and is inconsistent with the spirit of Article 8 of the Constitution, which guarantees the liberty and the security of a person. Therefore, it shall be invalidated from the date of this interpretation. Article 90 of the Criminal Code, as enacted and promulgated on January 1st, 1935, and effective from July 1st of the same year, provides a person who makes the commission of a crime, a habit, or occupation, or commits an offense because of habits of loitering or vagrancy and laziness may, after execution or remission of punishment, be ordered to enter a labor establishment to perform educational compulsory labor. Article 3, paragraph 1 of the Rehabilitative Measures for Burglar and Offense Criminal Acts, as amended and promulgated on July 29, 1992, states that the burglars and offense criminals who are habitual offenders over the age of 18 and meet one of the following conditions shall be ordered to perform educational compulsory labor in a labor establishment prior to the enforcement of their sentencing. First, being a habitual criminal. Second, engaging in the habitual commission of larceny or possession of stolen property as a profession. Article 3, paragraph 3 of the Organized Crime Prevention Act, as enacted and promulgated on December 11, 1996, provided that those who commit the crime under paragraph 1 shall, after execution or remission of punishment, be ordered to enter a labor establishment to perform educational compulsory labor for a period of 3 years, and those who commit the crime under the first sentence shall work for a period of 5 years. These provisions, which impose restrictions on the liberty and the security of individuals, violate the principle of proportionality as outlined in Article 23 of the Constitution. Furthermore, Article 3, Paragraph 3 of the Organized Crime Prevention Act fails to meet the requirement of the constitutional principle of clear distinction and is inconsistent with the spirit of Article 8, which protects the liberty and the security of individuals. Therefore, J1 interpretation number 528 of this court shall be appropriately amended within the relevant scope. Starting from the date of this interpretation's publication, it is established that any educational compulsory labor prescribed by the final judgment which has not been executed or completed shall be exempted from execution. In the case where the person liable to penalty is to undergo imprisonment, the duration during which they await execution of imprisonment at the original labor establishment shall be counted as part of the period of execution of imprisonment, starting from the publication date of this J1 interpretation until the prosecutor ordered the execution of the imprisonment. Reasoning. The applicant, the criminal courtroom 1 of the Supreme Court, hereinafter referred to as applicant 1, handled the case of Supreme Court 107 Tai Xiang 2237. 2018 of the Organized Crime Prevention Act and found that the provision of Article 3.3 of Organized Crime Prevention Act, which requires that those who participate in a criminal organization, regardless of the severity of circumstances, all shall be sent to a labor facility for educational compulsory labor for 3 years before the execution of the sentence, violated Article 8 of the Constitution and due process of law, as well as the principle of proportionality under Article 23. The rehabilitative measures of liberty and the security of a person should be subject to consideration of the case's circumstances by the trial court to determine whether or not to declare it and its content to conform to the substantive due process of law and the concept of a fair court, as well as to maintain the balance between the punishment and the rehabilitative measure. J1 interpretation number 528 also ruled that it was necessary to make changes due to the amendment of the Organized Crime Prevention Act and suspended the litigation process for constitutional interpretation. The Criminal Court Room 3 of the Taidong District Court in Taiwan, the applicant hereinafter referred to as applicant 2, handle cases of violation of the Organized Crime Prevention Act, which are the Taidong District Court 107 Su 31 63 157 2018 and found that the provision of Article 3, Paragraph 1 of the Organized Crime Prevention Act, which requires that those who participate in a criminal organization, regardless of the severity of the circumstances, will be sent to a labor facility for educational compulsory labor for 3 years before the execution of the sentence, did not give judges discretion in individual cases and may lead to a suspicion of overbroad coverage, which may cause an imbalance in severity of cases and violate Article 8 of the Constitution on due process of law and the principle of proportionality under Article 23. Therefore, they suspended the litigation process for constitutional interpretation. In the criminal case with the docket number 107, Jingsu 10, which was heard in Criminal Court Room 4 of the Taiwan Nantou District Court. The applicant hereinafter referred to as applicant 3 raised concern regarding the application of Article 3, Paragraph 3 of the Organized Crime Prevention Act. The court imposed a 3-year sentence of educational compulsory labor on the defendant without adequately considering the severity of the offense or the necessity for prevention and correction. Whichever interpretation number 528 previously deemed this provision constitutional, and the subsequent amendments to the Organized Crime Prevention Act have introduced changes such as the inclusion of pre-trial educational compulsory labor and an expanded definition of criminal organization. As a result, the Constitution's basis of trial interpretation number 528 is now under question. Consequently, the court has suspended the proceeding and submitted a request to this court for a constitutional review. The judge presiding over cases including 109E 318, 109 Shen 169, and 108 Jiansu 269 in Criminal Court Room 5 of the Taiwan Taichung District Court, hereinafter referred to as applicant 4, has expressed concern regarding the application of various provisions under the Organized Crime Prevention Act. These provisions include Article 90. Paragraph 1 and 2 of the first sentence of the Criminal Code, Article 3, Paragraph 1, and Article 5, Paragraph 1 of the Rehabilitative Measures for Burglar and Offense Criminal Act, as well as Article 3, Paragraph 3 of the Organized Crime Prevention Act. The applicant argued that these provisions, which allows for imposition of educational compulsory labor in addition to imprisonment, have a strong punitive nature and restrict the protected liberty and the security of individuals under Article 8 of the Constitution. The imposition of educational compulsory labor as a rehabilitative measure, separate from the execution of punishment, involve a dual evaluation process that infringes upon the due process of law and the principle of proportionality, as outlined in Article 8 and Article 23 of the Constitution. Respectively, in light of this concern, the court has decided to suspend the proceeding and seek a constitutional review from this court. It is therefore request that the trial interpretation number 471 and the number 428 of the Judicial Yuan to be amended accordingly. Furthermore, in the larceny cases 109E 1917, the court has similarly suspended the proceedings based on the same grounds pertaining to Article 90, Paragraphs 1 and 2 of the first sentence of the Criminal Code, and Article 3, Paragraph 1, and Article 5, Paragraph 1 of the Rehabilitative Measures for Burglar and Offense Criminal Acts. The 4 applications filed by applicants 1 to 4 are all in compliance with the requirement for judges to request constitutional interpretation, as set forth in trial interpretation number 371, 572, and 590. Therefore, they are all accepted. The cases to be reviewed and the subject matter of the constitutional interpretation accepted for each petition are listed in Appendix 1. Applicant Su Haike, hereinafter as the applicant 5, claims that the provision Article 90 of the Criminal Code as applied in the final and the conclusive judgment as shown in Appendix 2 is unconstitutional in his case of fraud. The reason is that refusing to work is a right protected by the Constitution, and the nation cannot force the person to work by law. Given that the punishment for continuous offenses was abolished in criminal code, there is no need to consider supplementing insufficient penalty with educational compulsory labor provision. Therefore, the system of educational compulsory labor no longer has the rationality and legitimacy to continue to exist, and the provision violated Article 8 and 23 of the Constitution. Applicant Huang Yangfang, hereinafter referred to as applicant 6. Claims that the provision of Article 90 of the Criminal Code, as applied in the final and conclusive judgment as shown in Appendix 2, is unconstitutional in the case of fraud. Applicant Long Shen Wang, hereinafter referred to as Applicant 7, claims that the provision of Article 90 of the Criminal Code, as applied in the final and conclusive judgment as shown in Appendix 2, is unconstitutional in the case of fraud. Applicant Xin Ling Cho, hereinafter referred to as Applicant 8, claims that the provisions of Article 90 of the Criminal Code, as applied in the final and conclusive judgment as shown in Appendix 2, is unconstitutional in the case of robbery and other crimes. Applicant P. Fu Chen, referred to as Applicant 9, claims that the provision of Article 90 of the Criminal Code, as applied in the final and conclusive judgment as shown in Appendix 2, is unconstitutional in the case of aggravated fraud and other crime. Applicant Xin Qi Chen, hereinafter referred to as Applicant 10, claims that the provision of Article 90 of the Criminal Code, as applied in the final and conclusive judgment as shown in Appendix 2, is unconstitutional in the case of aggravated fraud and other crimes. The reason is that the final and the conclusive judgment imposed imprisonment and also declared 3 years of educational compulsory labor under the provision. And although Article 98, paragraph 2 of the Criminal Code provides that after the execution of educational compulsory labor punishment or partial exemption, the entire or partial execution of the punishment may be exempted. In reality, it is rare to exempt the entire or partial execution of the punishment, making the provision meaningless. The accumulation and the progression of the punishment cannot be continued, and there is no relief for educational compulsory labor without the possibility of legal remedy, which violates the principle of proportionality and the principle of preventing double jeopardy, and only authorizing one punishment under the Constitution. The applicant Xin Yao Huang, Zhao Xian Huang, Yi Chu Lu, Li Yu, Jiang Mingxu, Wei Qi Guo, Yu Yuan Mingpeng, Qian Wenxian, Cong Li Guo, Yi Changyan, Jia Jianglu, Yu Yinxian, Yi Wei Zhang, Guo Wei Lin, Wen Yi Li, Yin Haozhou, Chu Qian Wang, Chen Nan Du Wu, Lung Hui Xian, referred to as applicant 11 to 29, contain that the application of Article 3, Paragraph 1 or Paragraph 5 of the Theft and Robbery Punishment Act as listed in Annex 3. In final and binding judgment is unconstitutional. They present the following arguments. With the abolishment of the provision on successive offense, the Criminal Code has adopted the principle of one crime, one punishment. However, in the final and binding judgment, imprisonment and the declaration of 3-year educational compulsory labor are imposed for the same criminal act. Moreover, during the imprisonment period, the offenders can also participate in various skill training. The execution of compulsory educational compulsory labor is indistinguishable from that of imprisonment. However, educational compulsory labor cannot be credited to the sentence, nor can it continue after the imprisonment period. Therefore, the imposition of educational compulsory labor beyond imprisonment violated the principle of preventing double jeopardy. It excessively encroaches upon the liberty and the security of individuals, contravene the constitutional principle of equality and proportionality, and fails to provide remedy for rejecting the continuation of educational compulsory labor and exempting sentence education, thereby violating the principle of due process of law. Applicant 25 also requests a constitutional interpretation of the provision of Article 90, paragraphs 1 and 2 of the first sentence of the Criminal Code. Applicants Chen Ting Huang, Su Han Wang, Chen Ju Tang, Han Huang Lian Peng, Jia Wei Cai, Qing Wei Chang, and Guang Chang Su, referred to as Article 30 to 36, have all been convicted of violating the Organized Crime Prevention Act. They contain the application of Article 3, Paragraph 3 of the Organized Crime Prevention Act, as listed in Annex 4 in the final and binding judgment, is unconstitutional. The argument can be summarized as follows. Regardless of the severity of the crime committed, the regulation imposes a mandatory 3-year educational compulsory labor, without considering whether the offenders require preventive measures or correction of their social risk. This results in a deprivation of their liberty and security, and the punishment exceeds the illegal nature of their actions, as it does not offset the prison term and effectively duplicate the execution or imprisonment, thereby violating the principle of proportionality. Furthermore, the execution or imprisonment already includes training programs within regular prison setting, which serve the same purpose as educational compulsory labor. It is also argued that the shortcoming in the punishment function should not be rectified by imposing educational compulsory labor on a small subset of individuals. The applicants from the 5th to 36 cases have all met the requirement stipulated in Article 5, Paragraph 1, Subparagraph 2 of the Act governing the interpretation of the Constitution of Judicial Yuan, here referred to as Grand Justice Act, and therefore their applications are accepted. The final judgment and the subject matter of the constitutional interpretation in the above-mentioned cases are listed in Appendix 2 to 4, and the content of the constitutional interpretation are listed in Appendix 5. The 39 applications filed by 36 applicants all relate to constitutional controversy of whether educational compulsory labor can be imposed on criminal offenders. As there are common issues involved, the cases are consolidated for joint consideration. After announcing the matter for oral argument, the applicants number 1 to 8, 11 to 27, and 30 to 35, as well as representatives from Ministry of Justice and the Judicial Yuan Criminal Department and their attorneys, were notified to appear for oral argument on October 12, 2021, in accordance with Article 13(1) of the Act on the Organization of a Constitutional Court. The parties number 9, 10, 28, 29, 36 were not notified to appear for oral argument as their application were filed after the period for announcement of oral argument. Additionally, expert witnesses and amici curiae from the Control Yuan and the National Human Rights Commission were invited to give their opinions. After the conclusion of the oral argument, the applicant Trudy Kuo et al. Filed a motion on October 21, 2021, requesting a further oral argument. However, after considering the evidence obtained during the hearing process, the Constitutional Court found no need to hold a further oral argument, and this is hereby stated. The summary of the statement made by the applicants and the relevant agency during the oral argument hearing is as follows. Applicant 2 assert that the provision stated in Article 3, Paragraph 3 of the Organized Crime Prevention Act, which imposes a mandatory 3-year educational compulsory labor sentence, regardless of the severity of the offense, significantly curtails the discretion of the trial judge. They argue that this inflexible approach may result in potential problem of disproportionality and the violation of the proportionality principle. In light of these concerns, they advocate for subjecting this case to the strictest scrutiny test, emphasizing the need for careful examination in the evaluation of its constitutionality. Applicants 5 and 6 of all their representatives argue in the oral arguments that Educational compulsory labor violates the principle of proportionality. First, from the perspective of suitability, the causes of criminal habits are diverse and complex. It is not effective to rely on educational compulsory labor as the only means, i.e., to provide skill or training to the person subject to disposition during the punishment period to solve the problem of a criminal habit. The key point may be how to help the person in custody to find a job after release. In addition, educational compulsory labor is not the minimum invasive means. There are other means, such as employment services, including vocational training and matching, protective restraint or community treatment, which are equally effective for correcting the person subject to disposition as well as less invasive. Moreover, from the perspective of cost-benefit analysis, declaring educational compulsory labor for 3 years across the board may result in short-term offender having to undergo compulsory labor for a longer period, which may result in an imbalance of severity in individual cases. It is also argued that there is no clear distinction between educational compulsory labor and punishment in terms of purpose, function, and institutional norm or practical implementation. It is further argued that educational compulsory labor violates the human dignity and the principle of prevention of double jeopardy. The provisions in the disputed issue in Appendix 5 violate the principle of legal certainty, etc. The Ministry of Justice argues as follows regarding relationship agency. Some applicants misunderstanding the practical operation of educational compulsory labor. In reality, educational compulsory labor is a benevolent law and the intention of the state toward a specific criminal. The training programs are established for individuals subject to educational compulsory labor. If there are extra slots available, inmates are allowed to participate in learning together. It should not be considered a violation of the principle of clear distinction simply because individuals subject to educational compulsory labor and inmates participate in the same training courses. Based on the empirical data, educational compulsory labor does indeed achieve the effect of reducing recidivism, which is in line with the principle of proportionality. As for the execution of distinction, it is currently being gradually improved, but this flaw does not render the entire system of educational compulsory labor unconstitutional. The Judicial Yuan Criminal Department, as the relevant judicial authority, asserts that the declaration of educational compulsory labor, the suspension of execution, and the exemption from punishment are all accompanied by adequate safeguards or procedural remedies. It maintains that there is no insufficiency in the protection provided by these measures. This court has thoroughly examine the constitutional petition, engage in comprehensive debate, consider expert opinions, review the opinion of the amici curiae, and conducted an on-site investigation of Taoyuan Skill Training Center of the Agency of Correction, Ministry of Justice on October 29, 2021. Based on these proceedings, this interpretation is made with the following reason presented. Okay.